Okay, let's dive in. Imagine you get, what looks like a totally standard letter, legal stuff,
Mhm.
from a law firm to a judge. Seems pretty mundane, right? But then you look closer, and buried in there is something, well, something genuinely surprising. Actually, maybe even a bit shocking. It's a claim about medical reports, substantially identical ones, being filed in lots and lots of different personal injury cases. It's like finding, I don't know, the exact same architect's plan being used for dozens of buildings that are all supposed to be unique.
It really is intriguing. And what's fascinating is how something like this, a seemingly routine request to the court, can suddenly shine a light on what's being called a potentially deep systemic issue. We're not just talking about one disputed document here. It's about a possible pattern. And if it's true, that could seriously, shake confidence in the whole legal process.
Yeah. Exactly. And that's precisely why we're doing this deep dive today. Our mission really is to unpack this whole complicated legal tangle. We want to explore how this one law firm's request to a New York court is bringing these pretty serious allegations out into the open. We'll look at what the allegations actually are and, importantly, why this could matter a lot. For the courts, obviously, but also for insurance markets and even potentially for regular people, for third parties caught up in this. So the goal is to cut through the dense legal language, pull out the key pieces of information, and figure out the real-world impact here.
And to do that, we're mainly looking at a specific piece of correspondence. It's a letter dated August 8th, 2025. It's from the Willis Law Group, PLLC, and it's addressed to the Supreme Court of the state of New York, Kings County. Now, this letter points to something else, a really crucial exhibit they've attached. It's called a verified bill of particulars. And this comes from a completely separate case. Alex Leonardo Zarita Kulake versus KFC U.S. Properties, Inc., and others.
Right. And maybe just quickly, for anyone not familiar, a verified bill of particulars. What exactly is that?
Sure. It's basically a formal legal document.
Hmm.
The plaintiff, the person suing, uses it to lay out their specific claims in detail. So what exactly happened, what injuries they claim they suffered, and crucially, the damages, the money they're asking for. It has to be sworn to, hence verified.
Got it. Okay. So with that background, let's get right into the core of it. What exactly is the Willis Law Group alleging here, this pattern of identical reports? So they represent the defendant and third-party plaintiffs in a case called Toribio, and they'd apparently already found 24 substantially identical operative reports, 24 of them.
That's right. And these reports were key to something called a proposed order to show cause, which is basically asking the court very formally to take some kind of urgent action, probably in this situation, to stop or address this alleged fraudulent activity. And they submitted that back on August 5th, 2025.
Okay, but then things took another turn.
They did. Because just before that date, literally the day before, August 4th, 2025, they found another one, a 25th report. And this one popped up in that verified bill of particulars from the other case we mentioned, the Zarita Kulake case against KFC.
A 25th report. Okay, now, what's so special about this one? Is it different?
Well, yes and no. According to the Willis Law Group, the actual content, the description of the procedure, was essentially identical to the other 24, a verbatim copy. But this 25th report had something extra added, a billing line item for neurolysis of adhesions.
Neurolysis of adhesions. Can you explain what that is?
It's a medical procedure. Basically, it's surgery to free up nerve tissue that's caught in scar tissue or adhesions. So imagine you have the same report, word for word, but then this extra, potentially costly procedure is tacked onto the billing in just this one instance, even though the narrative description didn't change.
Wow, okay. So Willis Law Group's main worry here, their core point, is that these aren't just similar reports. They're calling them, and this phrase really stands out, verbatim replications purporting to detail individualized patient care. Verbatim replications. That's pretty stark language.
It absolutely is.
Yeah.
And they don't pull any punches about the potential harm either. They issue this really serious warning in the letter. They say, and I'm quoting loosely here, that if this isn't stopped immediately, the continued submission of these reports poses ongoing harm. Harm to the courts, to insurance markets, to unsuspecting third parties, and of course to their own client.
And they mentioned how long this might have been going on.
Yes, they claim this has been happening for 4 years and counting. 4 years. And then they add this really powerful line, money damages do not correct a poisoned record. Intro. Which really makes you think, doesn't it? How do you fix damage to the basic trustworthiness of the legal system itself?
That is a heavy statement, a poisoned record. And I think to really grasp why they see this as such a profound threat, we need to zoom in a bit. Let's look at that specific case where the 25th report emerged. Zurita versus PFC. This is where we see the sort of ground-level details. So the plaintiff, Alex Leonardo Zurita, the claim is a trip and fall, December 2nd, 2022, about 9:04 at night. And it happened in what's described as a defective, dangerous, hazardous condition, specifically in the parking lot next to a KFC on Northern Boulevard in Queens, New York.
Right. And the plaintiff's lawyers, that's Willis Law Group, they laid out claims of negligence against the defendants. That includes KFC U.S. Properties and some other related companies. The allegations are pretty standard for this type of case, failure to maintain the property, manage it properly, design issues, inspection failures, all leading to what they call a nuisance, trap, and hazard. They describe the specific condition as defective, cracked, uneven, broken, irregular, misleveled. Gives you a pretty clear picture.
Okay, but here's where it gets, I think, really interesting, especially when you layer on these allegations about identical reports. The plaintiff's lawyers didn't just say KFC should have known about the bad parking lot. They claimed KFC had actual notice. And how did they claim that? By pointing to other lawsuits, previous lawsuits, for accidents that happened at the exact same spot.
Ah, okay. So not just constructive notice like they should have known, but actual notice because they had been sued over it before.
Exactly. They specifically named two other cases, one called Marvin J. Cisneros Alvarado v. KFC U.S. Properties, accident date January 22nd, 2022, and another one, Michael Vargas v. Leondis Associates and QSR NY LLC, accident date August 4th, 2022. Same location.
So that definitely suggests this wasn't, a brand new problem with the parking lot. It points towards a potentially recurring issue there.
A recurring issue, right? At the very least, recurring claims about the location.
Yeah.
Now, let's connect that back to the Zurita case itself and the injuries being claimed, because they are extensive. We're talking about a whole range of pretty severe injuries. The spine, the shoulder, the knee.
Okay, let's break those down. What are the specifics?
All right, so for the cervical spine, the neck area, they're claiming things like a C6, C7 midline herniation, C5, C6 midline protrusion, radiculopathy, that's nerve pain shooting out from the spine, severe muscle spasms, and they state there's a need for future injections, possibly more surgery. And significantly, this section mentions the procedure done on May 9th, 2024 by a surgeon Alexios Apazidis, MD. And that's the procedure where that extra neurolysis of adhesions billing appeared, the one from the 25th report.
Ah, I see. So connecting that specific billing item back to this claimed injury. Okay, what else?
Then there's the right shoulder. Claims include a complete rotator cuff tear, a labral tear, that's the cartilage rim in the shoulder socket getting damaged. Also impingement syndrome, where tendons get pinched, and adhesive capsulitis or frozen shoulder. Again, stated need for future injections or surgery. That procedure is apparently done on May 8th, 2023 by a different surgeon, Ajoy K. Sinha, MD.
Okay, so neck, shoulder, what about the knee?
Right, knee too. Claims there include an interstitial tear of the ACL, that's the anterior cruciate ligament, and a tear of the lateral meniscus, another piece of cartilage in the knee.
Again, requiring future treatment.
Yes, future injections or surgery mentioned there too. And that procedure was also performed by Dr. Sinha, the same surgeon who did the shoulder, back on April 10th, 2023.
And was there anything else? Lumbar spine, perhaps?
Uh-huh. Lumbar spine, the lower back, an L5S1 midline herniation claimed there, along with severe muscle spasms.
So quite a list of significant injuries across multiple body parts.
Definitely. And the overall impact claimed is pretty substantial too. Confinement to bed and home for about 10 months, on and off, after the accident and surgeries. Plus, the claim that most of these injuries are likely permanent and progressive, meaning they could get worse over time.
And I imagine the costs associated with all this are significant.
Oh, yeah. The document lists the special damages. Those are the specific, quantifiable costs. For physician services alone, it says approx. $450,000 and continuing.
Wow, $450,000 just for doctors.
And continuing. Plus, thousands more listed for medical supplies, hospital bills, medical devices, even transportation costs.
So when you see these kinds of extensive injuries and these very high costs claimed in one case, and then you have this backdrop of an allegation that the operative reports for some procedures might be identical across different cases, you can see why the stakes get very high very quickly.
Absolutely. It really brings us to the sort of bigger picture here, the legal maneuvering and the potential systemic issues. And there's another interesting detail from the Willis Law Group letter regarding the different law firms involved.
What's that?
Well, remember the plaintiff's attorneys in the Zurita case? Willis Law Group.
Yes, the ones who cited the prior lawsuits for actual notice.
Right. Well, according to Willis Law Group, Bogaraz Law Group was the only law firm out of all the different cases. Willis notified the only one to actually file an objection to a litigation hold notice that Willis sent out on August 2nd, 2025.
Hmm, okay. And the litigation hold notice, just to clarify, is basically a formal demand saying, preserve all relevant evidence, don't delete anything, because it might be needed for a lawsuit.
Yeah.
So only one firm objected to that. That is interesting.
It is, isn't it? What do you make of that? Why might just one firm push back against preserving evidence in this context?
Well, it's hard to say for sure without their reasoning. It could signal any number of things, maybe a very different legal strategy compared to the other firms involved. Perhaps a strong belief that the notice was improper or overly broad for their specific case. Or maybe, just a more aggressive stance against this whole investigation into the reports. It definitely raises a question about the different ways law firms are reacting to these quite serious allegations.
Yeah, it adds another layer to the whole situation. And it really circles back to that core concern from the Willis Law Group that, quote, again, money damages do not correct a poisoned record.
Exactly. They're arguing that if these reports are unreliable, or worse, fabricated, and they continue to be used in court, it doesn't just potentially harm the opposing party in that one case. It could severely prejudice other parties in completely different lawsuits if the same questionable evidence is being recycled. And fundamentally, as they argue, it risks undermining trust in the entire justice system. If the evidence itself is suspect, how can you trust the outcomes?
It really makes you pause and think about the potential ripple effects, beyond just the dollars and cents of one settlement or verdict. So, if we connect all these dots, what does this specific legal fight, this letter, this one case, what does it all mean for you listening to this?
Well, I think it highlights some really crucial things, like the importance of legal transparency, the absolute need for integrity in the evidence that gets presented in our courts. And it shows how public confidence in the whole legal process, and maybe even downstream industries like insurance, can be affected by these kinds of allegations.
Absolutely. And it underscores just how vital it is for lawyers like the Willis Law Group in this instance, and for the courts themselves, to be incredibly vigilant, identifying and challenging things like potential verbatim replications in crucial documents like medical reports. It's not just procedural nitpicking. It's fundamental to ensuring fairness, and it's about preventing potentially fraudulent claims that could, in the end, impact everyone, maybe through higher insurance costs or just a general erosion of trust in the system that's supposed to deliver justice. That vigilance seems key. So as we wrap up this deep dive, maybe the final thought to leave you with is about this delicate balance. On one hand, you have a plaintiff's fundamental right to seek damages for real injuries they've suffered. That's crucial. But on the other hand, you have the court's essential role, its duty, to scrutinize the evidence that supports those claims rigorously. And maybe cases like this, with allegations of identical reports and massive claimed costs, really underscore how critical that scrutiny is, especially now, in an age where we have huge amounts of data flying around and litigation can get incredibly complex. Maintaining the integrity of the process, ensuring the record isn't poisoned, as Willis Law Group put it, it requires constant attention from everyone involved. It makes you think about what other patterns might be out there waiting to be uncovered.